Good evening and good morning, depending on where you're joining us from. This is Arti Maharaj with Ethisphere. Thank you for joining us for this evening's webcast on managing corruption and third-party risk in India. This webcast is brought to you by Baker McKenzie, the Business Ethics Leadership Alliance, also known as BELA, South Asia Chapter, and Ethisphere. Leading today's discussion are Ritu Jain, Chief Compliance Officer for Asia at General Electric in Gurgaon, Alina Arora, Partner at L&L Partners in New Delhi, Richard Dean, Partner at Baker McKenzie in Washington, D.C., and Jerome Thomas, Partner at Baker McKenzie in Chicago. Moving on to slide 2. Before I turn it over to our speakers, I would like to run through some quick housekeeping tips. This is an hour-long webcast, and we will reserve time before the top of the hour to take any questions you may have. The questions feature is built into your GoToWebinar application, so please feel free to send us your questions and we will try our best to address them all. All registered participants of this evening's webcast will receive links to the recording and the presentation once this webcast ends. Moving on to slide 3. Once again, thank you to our speakers from the US and India for coming together to take us through third-party risk and effective compliance in India. Special thanks to our BELA South Asia founding member companies and Integrity Partners for making this webcast possible. At this point, I would like to turn it over to Richard Dean from Baker McKenzie to start the discussion.
Hello, everyone, and thank you for the opportunity to present to you all today. We've got what we hope you'll find to be an interesting program. Just looking quickly at the agenda, we're going to spend some time talking about the nature of the challenges that global companies are facing in India these days in the first part, then focus particularly on enforcement issues in India, looking at recent developments in the law and enforcement policies of the Indian agencies. And then at the end, Ritu is going to take us through some practical perspectives on what are the particular third-party risks and how companies are facing them. And of course, I think all of you know very well the wonderful reputation that GE has in this area that really is at a global level in addition to what they're doing in India. So we're looking forward in particular to her comments. But let me just kick this off by putting this in some context. Jerome and I and others in our practice spend our time these days in investigations of corruption overseas for many U.S. but also global companies. And in addition to places that have been common areas for corruption issues over the years, you think about the former Soviet Union, China, increasingly Brazil. What we have seen in our practice is now a much greater focus on India. And there are reasons for this, and many of you be quite familiar with these. But in the early days of advising companies on corruption risk in India, at least our work tended to be more in the area of customs type payments, smaller payments made, and how would companies handle those kinds of issues. But in recent years, and Jerome will focus on this particularly, there are many more cases now, major FCPA cases that are focusing on India. And the corruption risks and issues are becoming better known. And this is, partly you would expect the progression of this just as the FCPA is enforced, but other factors have been important. For example, there have been major cases in India that have been started by whistleblowers, and one or more of these whistleblowers have been compensated under the U.S. Dodd-Frank bounty program. So there's, these kinds of factors are leading to these cases becoming more, more important. And I think overall, at least from a perspective of an American lawyer, India itself as a vibrant democracy with a market economy and a free press, these are the kinds of circumstances that lead to not only a greater focus on corruption, but the likelihood that it will be publicized. So all of this creates a kind of volatile context for us to talk about these issues. In the meantime, in the U.S., enforcement of the FCPA remains strong. There hasn't been any change under the new administration, nor do we expect to see any material change in the aggressive enforcement posture of the U.S. authorities. What we do see, though, is increasing cooperation between the U.S. and Indian authorities, and in particular, a trend of the Indian authorities opening investigations into matters that have been resolved in the U.S. In other words, we negotiate a resolution with the Department of Justice or the SEC, that becomes public, and the Indian investigation then commences, which is, of course, a great concern for companies. And you add to this the developments in Indian law and a greater enforcement awareness locally, and it's quite a set of challenges for companies to face. So what we're going to try to do in the time we have together today is give you some sense for what the issues are and what are the best approaches to addressing them. So just moving along here, these are kind of perspective, these next two slides. I mean, this slide 7, it illustrates my point about the growing importance of India in FCPA cases. If you looked at this over time, as we've got some data for you on this, you'll see that this is increasing, and the particular ways bribes are paid, the use of third parties, things like that, are becoming more and more evident. So if you just then move to the next slide, this puts India kind of in perspective in the rest of Asia. You see its ranking here by Transparency International. That rank of 81 would put India for most companies evaluating risk in their due diligence programs and so forth. That ranking of 81 would mean that India is considered to be a high-risk country. And you can see when you kind of compare it to the rest of the list that the perceived risks of corruption in India are quite high. So just moving to the next slide, I'm going to turn now to Alina, and Alina, ask you to talk a bit about these bribery risks as you see them, please.
Thanks, Rich, and hello, everyone. Like Rich just mentioned, we also have an exhaustive experience of working on multi-jurisdiction investigations with respect to companies that have business in the US and in India, as well as whether it's from the UK or global presence. And there's certain, practices that are more prevalent in the Indian subcontinent and that are discernible and evident. And I'm going to just walk you through some of those, which some of you may already be aware of. First and foremost, I think, is the key concern of using third-party intermediaries or liaising agents, as they're normally called here. And the notion that if a third party that is engaged by a corporation to go ahead and liaise with government public officials and make payments is not going to be a risk or an issue under the Indian Prevention of Corruption Act. So typically what we observe is most corporations will end up engaging consultants. Um, that's the common terminology that they would use for a third party intermediary to assist them to obtain various kind of licenses or permits or approvals that they may require to conduct a business. Associated with this practice, what we've seen is the concept of making facilitation payments. Now, while facilitation payments may be understood a bit differently in US law, under Indian law, we do not have the concept of a de minimis or facilitation payment being an exception. So if any payment is made to obtain a license or permit, and even if there is no discretion and it's automatic, it would be construed to be a bribe. And what we do see is that this practice of making payouts to get various license and permits just to kind of overcome the timeline and the bureaucracy is quite prevalent. And depending on the sector you're operating it, there are certain sectors that are highly regulated, and there are multiple licenses and permits that you require not only to commence the business, but to keep operating the business on a day-to-day basis. So that becomes a kind of a high risk in the Indian context for doing business. The other practice, which is kind of a cultural aspect to the country, is the concept of gifting on various occasions. And this is not your usual gifting, but the gifts that you would see on various local festivals like Diwali would be quite excessive and exorbitant. It would also, in certain sectors such as pharma and healthcare, go into organizing or sponsoring various foreign trips or events under the garb of calling them training events, etc. But I think basis what has been happening in the Indian subcontinent, it's quite evident and pretty much understood that it's basically a means of trying to bribe the officials to get certain undue advantages and benefits. In addition to that, I think one key point related to all of these is the accounting standards and finance controls that you would find within companies in India. What we do notice is that despite the fact that there has been an improvement in the recent past, it is still not as robust to ensure that the checks and balances and books and accounts are maintained in such a manner that use of petty cash or cash payouts is controlled and regulated. And that in itself leads to various issues of knowing exactly what the monies are being utilized for and how is the bookkeeping being maintained. And that's a key risk because a lot of time the smaller bribing day-to-day operational issues will be met out of the petty cash that a company maintains. And the smaller, as we call chai pani payments, facilitation payments, which are given to the local public officials, go out of that petty cash that is maintained by the company. And the accounting for that will obviously not be as robust, and the controls around it would not be very robust. Related to this, and I think while this has been a risk, this is going to change, but I'm going to just talk about it a bit, is the manner in which the business was typically conducted in the Indian context. It is kind of cultural to assume that business is done in a particular manner in the country, and that used to typically happen because of the lack of enforcement, and therefore the tone at the top of or the focus of the Indian management would be, well, if you have to do business in this country, this is how it is done. And pretty much there would be what we would say is the lack of commitment to compliance. One, there is no enforcement, and on the other side, the issue of, well, that's the way to do business here. Moving on is the issue that the country faced in terms of red tapeism and bureaucracy, and the fact that to get various kinds of licenses and approvals to run your business, the red tapeism and bureaucracy could be quite time consuming and frustrating. And there would be the point in time where the management would be, well, we need to get a process and get to do business. And typically that's the point where you would have this third party consultant who would be engaged by the company, and the company will say, well, all's good, he's going to handle it and get the business going to deal with the bureaucracy and the red tapeism. But what you need to understand is, right there, that consultant that you've engaged is going to be going out and doing something that is going to cause an issue for the company and the management. Now, these issues, so to say, were prevalent and are prevalent, but things are changing. And as we go forward, we're going to talk about what are the changes that have come about in the Indian law and how it makes it more imperative to deal with these risks in a more efficient manner while doing business in India. And, the change that this legislation, amendments to the legislation, is going to bring about. Just touching upon this, I think one thing I would definitely want to talk about is, depending on the sector that you're doing business in India, the risks are going to vary. While the broader contours of using consultants or liaising agents, gifting or facilitation payments might be the same, there would be specifics depending on which industry are you in and which specific state are you operating in. There are certain states that are more susceptible to corruption as opposed to certain others, and therefore an analysis of the sector and the industry and the state become important. So just broadly, we have a central legislation, and then superimposed on that there would be state-specific legislations that could be regulating the business or industry that you are in, that could throw up additional challenges that you would need to address.
Thanks, Alina. Ritu, is there anything you'd like to add to Alina's comments?
Hey, Richard, thank you so much. I think Alina covered the risk areas pretty well. The only thing I would add here is, just as the risk profile varies by the industry, similarly, the program that we as companies need to put together to mitigate and identify these risks also has to be customized based on who we are dealing with, the kind of third parties that we are engaging with, and what's the industry that we are in. So it is not just one way. It is definitely understanding the external landscape, the regulatory environment, but also figuring out how we are organized. The risk program that a large multinational would put in place may not be even feasible for a small company. Similarly, when we think about the small and medium enterprises in the country, they have very little wherewithal to put in extensive compliance measures, integrity measures, and therefore, how do we influence this ecosystem wherein everybody is playing fair and square, and nobody is as a competitive disadvantage simply because they are more compliant than the others. So I think that sort of adds complexity to dealing with bribery risks and dealing with third parties. And of course, I can touch upon more on this area in my last section.
Great, thank you very much. So Jerome, over to you, please, to talk about the perspective from the FCPA.
No, absolutely. Thank you, Rich, and good afternoon, everybody. So we have here a list of all of the FCPA enforcement actions over the past 17, 18 years that were substantially focused on Indian-related conduct. Going to Rich's earlier point, which is the evolution of these cases in our experience, in our experience, and frankly in the SEC and the DOJ, which are the two U.S. agencies that have FCPA enforcement in the U.S., the cases and the understanding that these agencies have for the Indian business model has emerged over the years. If you go down to the bottom of the chart to the Dow Chemical case in 2007, that case is very much akin to the historical government understanding in the U.S. and the types of cases that they would bring, focused on smaller payments made in order to obtain, label registration or permits or other types of registrations, customs type payments, more the transactional, day-to-day, paperwork type and process payments. But as the years have sort of gone on, the SEC and the DOJ have become increasingly more focused on other types of conduct, more of the conduct in the improper payments made in connection with sales-related activities. So if you look at, for example, the last 3 years, a couple of trends that we note from that consistent with these themes. One is that all of those cases, all 7 cases in the last 3 years, 2018, 17, and 16, involve payments or conduct involving third parties. Ritu is going to talk a little bit about that later, but it bears reinforcement that third parties remain at the forefront of the U.S. government's FCPA enforcement initiative in India. Interestingly, though, the type of conduct alleged in these cases in the last 3 years shows a marked difference from what the SEC and the DOJ's earlier enforcement priorities were. For example, over the last 3 years, of the 7 enforcement cases, 5 of them involve what we call sales-related improper payments made to officials or representatives at a government customer in India in order to obtain a sale or favorable treatment in connection with the sale of products. That represents a significant change in the development in the SEC and the DOJ's mindset and thinking in how they approach these cases. They now have institutional knowledge on how business works in certain industries, in particular in India, and are leveraging that knowledge to really bring cases more focused on the sales process. Another trend that comes out of here is, while one industry over the last 3 years doesn't seem to be the focus, if you will, it doesn't seem to predominate over others in the types of cases that the SEC and the DOJ are bringing. A closer review shows that 3 of the 7 cases in the last 3 years involve conduct by what we'll call companies in the consumer goods industry, 2 in the spirits industry being Beam and Anheuser-Busch InBev, and then Mondelez. And then 2 in the life sciences pharma device space. So of the 7 cases that the U.S. government has brought over the past 3 years in India or related to Indian conduct, 5 of those, a significant majority, relate to 2 industries: consumer goods and life sciences devices. And I think that's reflective of the economies of scale in the SEC and the DOJ's mind. They have spent an immense amount of time developing a working knowledge in these industries. Having spoken with the deputy of the FCPA unit at the SEC last August, he specifically mentioned how he feels like he spent a lifetime learning about the Indian spirits regulation market, and has been using that knowledge in other cases that he's been working on at the SEC. So it shows this level of institutional knowledge in the U.S. government. The third point I want to mention here is, while you see a lot of SEC resolutions, and then those resolutions typically tend to be at the books and records and internal controls level, you don't see the Department of Justice predominating in cases that they're bringing. The SEC seems to be bringing far more. A couple quick points there. One is just because we don't see a parallel Department of Justice resolution in publicly announced or in this chart does not mean that there was not an active Department of Justice investigation in that investigation. In fact, in most, if not all of these investigations, there was an active DOJ as well as an SEC component. So the Department of Justice is actively involved in these India cases, and frankly is in many cases driving the charge for cooperation with Indian law enforcement authorities. The second thing I just want to quickly reference here is that while you see that the SEC typically resolves cases in India for books and records and internal controls, and the Department of Justice typically brings the bribery charges, that doesn't mean that the SEC's allegations have nothing to do with bribery. Quite to the contrary. Most of these allegations, most of the factual allegations in the SEC's cases in India involve bribery-related conduct. But for various reasons, including from an evidentiary or from a jurisdictional standpoint, they are limited in their ability to bring those bribery charges. So instead, they bring and cast the bribery charges in the language of a books and records and internal controls charge. That does have a knock-on effect at resolution with the Indian law enforcement authorities and the risk in India. And certainly Alina and I have talked about that, and she can talk about that in the later slides. I just wanted to make sure that I was sort of setting expectations here pretty clearly. Masha, if we can go to the next slides. So we did these next two slides. We talk a little bit about and give some detail on some of the more recent FCPA cases involving India. I'm going to just, we don't have time to talk about all of these. I just want to drop reference to a couple of issues in some of these cases for you to think about. Stryker is an interesting case because Stryker, of all of those cases we just talked about, seems to be the exception to the rule. It's not really a case that involves in India with respect to Indian conduct. There are other allegations in that case where there is bribery-related charges. But in the India component of Stryker, these SEC's allegations are really focused on two things. One, which is Stryker providing its distributor with increased margin, which would then be used or passed along on paper, not in actuality, on paper, to the end user, who would then use that inflated invoice as a basis to seek reimbursement from, these are private hospitals, by the way, in India, to seek reimbursement from insurance companies or other customers in India based on those inflated invoices. In addition, the SEC alleged that the company didn't maintain sufficient documentation and support for transactions in what they alleged are 27% of the transactions tested in internal forensic review in high-risk accounts. And to me, that last one really sort of summarizes what is one of the key, in fact, risks, corruption risks from a U.S. perspective, from a U.S. law enforcement perspective in India, which is documentation and support for transactions. We see a similar issue on the next slide in Oracle. But at the end of the day, the SEC in particular, but also the DOJ, is very focused on if they can't show there's actually been a bribe paid. Very focused on, from a public company perspective, what is the level of documentation that underlies invoices that have been paid by the company's subsidiary in India, and very much concerned about the controls that have been applied in making those payments. So, for example, I've had a discussion with members of the FCPA unit on a case I'm working on, and even aside from any concerns regarding bribery, and at this point, the SEC doesn't seem to have a great feel for whether there are issues of bribery or not that they are thinking warrant enforcement action. And I don't think there are. The SEC is still focused on the controls related to the report that underlied invoices for payments that were made to an agent who was involved in assisting a client get regulatory approvals in an Asian jurisdiction. Very much focused on what are the controls that are in place that are ensuring that the finance function is talking to the business function prior to invoices getting authorized, that there is a repository of support or documentation behind each invoice, which can be pulled out after the fact in many cases, as we're seeing from the Stryker case, to support what they would call higher risk payments. Higher risk payments are payments that they view to, third parties acting on the company's behalf, particularly in connection with government official representations. What support underlies those? Very much can be where the rubber hits the road, if you will, on a U.S. law enforcement investigation, and can mean the difference between a years-long investigation or being able to refute any concern by the government early on. So again, we can stress that the documentation practices are key and integral to addressing U.S. law enforcement concerns. Masha, next slide. And so, talking about, approaching, compliance issues in India, obviously, third-party due diligence and maintaining documentation are significant steps. Ritu will talk about this a little later on. And before I get into the M&A diligence on this slide, I just want to sort of acknowledge that, if we gave the SEC and the DOJ a shot of truth serum, they would acknowledge that no third-party due diligence process is 100% foolproof. It cannot prevent all payments that might be viewed in hindsight as problematic. While in the midst of a case, you might feel like they don't really live up to that view. In large part, having a process in place that is intelligently designed to identify the high-risk third parties and having an appropriate and tiered level of vetting different third parties based on their risk and not treating all third parties the same, and then having that process live. So as new third parties develop, and for example, consortium partners is now something that the SEC and the DOJ, I think, are starting to take a look at. Consortium partners. As those types of third parties come to sort of be a part of a business's day-to-day life, do you treat those consortium partners or those consortia as a third party for diligence purposes? So having the process live and maintaining the documentation, the proof of that diligence. Doing things like that while never providing 100% complete defense in hindsight are incredibly effective in grappling with a lot of the SEC and the DOJ's concerns in FCPA cases in our experience. And then obviously there is, M&A due diligence. Look, M&A due diligence is a huge issue with the FCPA enforcement in the United States. Most of the FCPA cases still involve some form of acquired company conduct. And so it's critical to have a risk-based due diligence process that starts out by figuring out what the risk target what the risk profile of the target is, and from there taking appropriate steps. Certainly contractual representations and warranties are one thing, and also thinking about the deal structure. Is this a stock deal? Is this a merger of two companies? Is this an asset deal? And then through diligence, carving out any assets or contracts, for example, that are potentially tainted is certainly a step that we see and we advise companies to consider along this process all the time. I guess the one thing that we see and really that can add value in the diligence review is doing some type of, if it's possible, a pre-acquisition review of transactions. It's those review of transactions that really sort of allows the buyer to get under the hood and to show it's taking the diligence process seriously. And we'll talk about that in a minute. If you're allowed to do that, or if you're not allowed to do that, and that would allow you to identify issues potentially earlier in the process. If you're not allowed to do the forensic review before the acquisition, we certainly encourage companies to, after the acquisition, have their internal audit functions or do a forensic review of that acquired company shortly after acquisition, sort of in connection with implementing the company's compliance policies and procedures. Why is this important? Because very recently, the Department of Justice has extended the FCPA corporate enforcement program to M&A conduct. What is the FCPA corporate enforcement program? For those who don't know, it's a program that says the Department of Justice, for companies that self-disclose FCPA or anti-corruption law issues, if they have effectively remediated, they've cooperated, and they've disgorged all of the ill-gotten gains from that conduct, if they've done those three things, barring extraordinary consequences, there will be a presumption that the company, once they disclose, gets a declination from the Department of Justice. It's a significant carrot that the DOJ is putting out there. Now, there are the devil's in the details on the corporate enforcement program, and there are a lot of questions about how it works in practice, but the gist remains: if you disclose, remediate, cooperate, and disgorge ill-gotten gains, you're presumed to get a declination. Well, within the last 6 months, the Department of Justice has now extended that to M&A successor liability for FCPA cases. So, for example, if you identify issues in diligence and you do all of those other things and you disclose the conduct at that acquired company, you will be presumed to get a declination. It puts a premium on doing pre-acquisition due diligence. That said, there are incidents where the DOJ acknowledges that if you can't do, or you're limited your ability to do pre-acquisition due diligence, and you find conduct after the fact, the same principles generally will apply. You should be able to get significant leniency, and likely, and in my view, is you should be entitled to a declination as long as you meet all the other criteria. But the fact of the matter is, you don't stand a chance to get a declination without having some type of pre-acquisition due diligence process and making sure it is fairly in line with industry standards. Masha, next.
Hey, Jerome, that's great.
Yeah.
Thanks for going through all that. I think we've given you all a couple of more slides on U.S. enforcement trends. Most of this we've already touched on, and then a slide, go ahead, Masha, in advance, on sort of give you an idea of the magnitude of some of these FCPA cases. I think we can predict with a high degree of confidence that in coming years, you're going to see resolutions jointly between the U.S. and Indian authorities, as you're seeing in these other countries. But just to make sure that we don't run out of time, I want to ask Alina now to pick up and go through the enforcement developments in India, please. Thanks, Jerome. That was great.
Indeed.
Elena, are you?
Can you hear me, Rich?
Yes, we can hear you now.
Apologies. So thanks, Rich. And given the paucity of time and the fact that I would like to cover the key changes that have happened to the primary legislation that governs bribery in India, which is the Prevention of Corruption Act, I'm going to go over the key changes without really going into the details and touch upon the most significant changes. So for everyone's consumption, there has been an amendment to the Prevention of Corruption Act, which is the primary legislation, just very recently in July 2018. And this is a watershed change in the way, corruption has been seen and enforced in India. What it has done is, prior to this change, primarily what was understood from the Prevention of Corruption Act was that it was catering to the demand side, that is, the public official receiving a bribe was construed to be committing an offense. Now, what this amendment has done is to bring about 2 to 3 new changes, which is one, it is clarified that the giver of the bribe, that is, any person who is giving undue advantage to a public official, is also going to be a separate offense. Now, that is not to say that prior to this amendment, the bribe giver could not be prosecuted, but there was no specific provision, and it was an interplay between this legislation and what we call the Indian Penal Code, where we had to use provisions like abetment and conspiracy to try and tie them together. Now, there is a clear-cut provision, and Marcia, you can move on to the next slide, which says that if an individual is giving a bribe to a public official, the bribe giver will be prosecuted. They have further gone on to introduce the concept that it does not matter when the bribe is given directly or through a third party. Now, this is another significant change where they have clarified that the use of middlemen or any third party is specifically going to be an offense. Additionally, in terms of the bribe giver, what they've gone on to do is introduce another specific section in the Act to say that a commercial organization that is seen to give any undue advantage to a public official can also be prosecuted. Now, this is significant for everyone doing business in India, because prior to this amendment, the Prevention of Corruption Act did not specifically envisage prosecuting companies for corruption issues. Now, that does not mean that there were no prosecution. There has been, and we are a common law country, there had been judicial precedents which had extended the provisions to bring corporates within the purview of the Act. But given the recent trends and changes that have been happening, and the understanding in the Indian subcontinent that it's important for corporates to hold ownership and responsibility, this specific provision has been brought about. Now, interestingly, it just does not say that the commercial organization can be held liable. It goes on to say that any person who is associated with the commercial organization who indulges in such a practice can make the commercial organization liable for the act of the person associated with them. Now, this is wider than third party or use of third party. A person associated with the commercial organization can be interpreted to mean your own employees, your officers, any third party consultant, any agent, any intermediary. So anyone who is associated with the business of the corporation engages any such practice could have an impact on the commercial organization, and they could be prosecuted. Commercial organization, interestingly, has been defined to include any body corporate that is incorporated outside India, which means if there is a foreign company, a company incorporated in the US or UK that has any business operations in India, it can be directly prosecuted for an offense of corruption in India. This is the first time we are seeing such a change where commercial organization has been defined to include companies incorporated outside India. So if you're a foreign corporation, you could either have a subsidiary, you could have a distributorship, you could have a supply arrangement, or you could have a joint venture. Either or way, in whatever manner, if you're doing business in India and you engage in any practice, you are going to be held accountable and can be prosecuted for that. Not just that, another specific provision has been included to say that the directors of that organization and the management can separately be prosecuted for that offense. Now, if we look at these changes that have been brought about, it brings about a whole new structure into place which clearly specifies the corruption risk in the corporate commercial world and extends it to a multi-jurisdictional level. Interestingly, what they have introduced, and I think they have taken the lead from the US FCPA and the UK Bribery Act, is to provide for a defense mechanism for commercial organizations by providing that if a commercial organization has adequate procedures implemented in the conduct of its business, that can be taken as a defense. It further specifies that the central government is going to issue guidelines to say what are those adequate procedures. Now, we don't have any guidelines that have been issued yet to say what those procedures are going to be. But based on the earlier drafts that were circulated before the enactment, what we understand is they were looking more towards the UK Bribery Act and the guidelines there, and it was kind of picking up concepts from the global procedures that have been implemented. So just kind of picking up the best practices that are likely to be included in the guidelines as and when they come in. I think to be able to avail of this defense, what we're looking at is to ensure that every corporate that is conducting business in India would need to have a clear and concise anti-corruption policy in place. There has to be a zero tolerance and tone from the top. There has to be conduct of training programs. There has to be effective whistleblower programs in place in the company. And obviously this has to all kind of tie into the nature of business that you're doing. And I think Ritu very appropriately mentioned earlier that it is not to say that every corporate needs to have the best standard, international gold standard. It has to be the international gold standard, so to say, but commensurate to the size of the business, the area of business, and the risk that it is exposed to in terms of the business it is undertaking within the country. So assuming and looking at the sector, if you do build in a good procedure or policy within your corporation, you can take it as a defense in the event you're prosecuted for any charges. Moving on, while this is not mentioned specifically, I just want to bring up one more point here very quickly, is that the new act has also recognized an ordinance, which is a pre-independence ordinance, but it's clearly included into the act to say and provide that the government has the ability to attach and disgorge all proceeds of corruption, which basically means that you're looking at similar provisions as in the US, where there could be attachment and disgorgement of all profits from any such activities. And while we don't have time to go into that, I think it kind of summarizes very broadly the large changes that have been brought about. And we are yet to see how this is going to be enforced. But clearly, what we are seeing generally as a trend in terms of corruption issues is that while there may not have been many successful prosecutions, the rate at which investigations are being initiated has increased. The CBI, which is the Central Bureau of Investigation, has in the recent past taken cases which you can, as you can see from the stats that are provided on the slide, there's been an increase in the number of cases that are being initiated. In addition to the CBI, which is the central body, there are anti-corruption bureaus at the state level, which means it falls within the police department specific to each state within the country, and there is an increasing trend of doing that, which means that corruption is being seen as a serious issue, and there is a definitive attempt to curtail and enforce action against any kind of corrupt practice. Now, moving from here, we have also seen a lot of large high-profile cases that have been picked up, and some of them are mentioned and you all may be aware of them. We've seen cases like the Rafael deal come up in the defense sector. We have seen the Punjab National Bank and Nirav Modi, who's a diamond merchant, come up in the financial sector. And in addition to that, we have Vijay Mallya, which has come up. So there have been very high profile cases that are being prosecuted and pursued very seriously that entail, for example, in the Rafael deal, there is this whole issue of some kind of middleman and corruption risk associated. In the Nirav Modi case, there is corruption at the operational level to kind of manipulate the banking system to get approvals for various kind of loans and defraud the bank and therefore the public sector funds. And the government is taking it very seriously and they're being prosecuted. And a result of some of these cases like Vijay Mallya and Nirav Modi, we've got and introduced a new legislation, which is the Fugitive Economic Offenders Act 2018. There was this trend in the country where a lot of these people would engage in such practices and flee the country, and it was becoming difficult to prosecute them. And this legislation intends to make sure that if anyone is trying to flee the country, they can be prosecuted under this new enactment. In addition to that, I think moving on as far as enforcement is concerned, very quickly, and I know I'm racing against time here, is what Rich also talked about, and Jerome, which is the increasing cooperation between the Indian authorities and the US authorities through what we call as the MLATs, or the Mutual Legal Assistance Treaties, where the US authorities are directly reaching out to the Indian government and through the enforcement agencies, seeking their assistance in enforcing and investigating cases of corruption that are multi-jurisdictional. And that kind of means that any kind of proceedings that are initiated in the US against any business or corporate that has a business presence in India, the US authorities are going to pick up the phone and speak to the Indian authorities, and the Indian authorities are going to then reach out to the relevant witnesses within the country to investigate and assist the US government in the proceedings, etc. So broadly speaking, I think I've tried to cover everything, and Rich, I'm going to hand it back to you. I think Ritu needs to pick up the next point on the trends, so I'm going to hand it over to her.
Yeah, thanks, Alina, very much. That was great, hitting the key highlights. Ritu, over to you now for the kind of practical perspective of in-house counsel.
Thanks, Richard. Appreciate the inputs from all of you, and Elena, thank you for teeing it up here on the Indian landscape. So, look, I think it all comes down to what do we do with these third parties and how do we manage the risks around them? And really, we have to start with identifying these third parties. Not all third parties are created alike, and they all come with a different set of risk area depending upon their scope, the relationship, the structure, and how much they are recognized as representative of a company. So really, if you look at what is here, you start with the simplest of them, which is your customer. And a customer could be an end user, an EPC company, an aggregator, but really an entity which is buying our product or service for an direct consumption or for as an input into their final product. Here, the risk is really limited to whether these entities are legit and whether these are conducting legitimate business operations, and they are not really a face of an illegal organization or an antisocial organization, because we don't want our transactions to be channels for money laundering. But then when you move beyond customers, you really start looking at very complex relationships. And Jerome talked about consortium partners. What we are seeing increasingly happen is as companies want to operate in newer geographies, they are looking for local partners in form of joint ventures, consortium relationships, in many cases, the end customer has such a large scope that it's not feasible for a particular company to operate by themselves or to bid for a project on a standalone basis. So that necessitates the requirement of having a co-bidder or a consortium partner to go and bid for a project. And then, we have also seen that in many countries there are local content requirements. The public procurement requirements require a local entity to be part of the bid, so that the government can hold them accountable and can feel safe about the project. And therefore, that also means that partnering with a local company about which we may not know enough or we may have no experience with also becomes necessary. So in all of these cases, they become even more complex depending upon the deal structure, equity investment, their own experience. In many cases, such companies have a lot of money and they can give funding, but they may not have enough experience. Or what we see very common in this geography is that these companies have really negligible compliance standards, and when you stack them up against the expectations of a multinational company, they fall very short. But it's not a choice to avoid them. So the question is, how do we mitigate our risks when we deal with them? And then the next two ones are really more common. Intermediaries are third parties which really help the company generate revenue. So they represent the company in front of an end customer who could be a private or a government organization, but what they really do is get more business. And here again, their risk profile varies from somebody who is a very, very high risk entity, basically like a sales representative who are commission based. They go and scout for orders, to an entity which is relatively less risk, like a value added reseller, which buys a product, adds enough value, and then sells it off to the end customer. So again, most companies, especially companies which are in flow businesses, use intermediaries to reach the market, to access the market. But again, their risk profile varies on who they are dealing with, who's the end customer, and how they are compensated. And then finally, vendors. Not all vendors are high risk vendors, and your vendor can range from a stationary vendor to a very high risk vendor like a custom house clearance agent, etc. So many companies have a way to the way they classify a vendor as a high risk vendor. One of the criteria invariably is whether these vendors are government facing. And these are entities who are experts in getting approvals, licenses, permits, and authorizations, and they interface between the company and a regulatory authority or a government body. One thing I would like to talk about here is we've been focusing so much on bribery risk all throughout, but all these third parties, they bring out risk areas more than just corruption and bribery. We share information with them. We do business with them. There is exchange of monies here. So we are talking about risks like money laundering, loss of intellectual property, regulatory compliance, competition issues. So we cannot really rule out all of those risks. So when we are thinking about mitigation, which I'll talk about in a minute here, we have to really think about risks beyond just anti-corruption and bribery. So let's move on to the next slide here. And before we think about mitigation, Masha, maybe you can flip over here. Yeah, thanks. So before I go into the compliance program and the risk mitigation, I think it's very important to educate our teams on red flags. More often than not, and I think Jerome mentioned it before, that we can do as much due diligence we want, we can put in all the controls we want, but really when these risks surface, and I'm talking from an in-house perspective, it's really when somebody sees something that doesn't look right, and then they raise their hand, and then you go deep and you say, oh yeah. So it's very important to look for those red signals. And a couple of them are really, starting with why are we using a third party? And just this basic question, when we ask to our business teams and we get answers like, oh, they have contacts and they have a lot of access, that itself seems like a big red flag. And you wonder, like, how are they using their contacts? So if the answers are not along the lines of because they have an expertise, or because we don't have the right resourcing, or because they are a niche player in this area, then you are really something to worry about, that why is this third party being proposed by the business teams. Many times the customer wants the company to use a certain third party. Here again, it's a red flag. So it's not necessarily something wrong, but it's something to watch out for. In cases where there are pre-qualified vendors, in an example of a public procurement process, and generally Indian public sector companies do have pre-qualified vendors, and it is suggested to pick one of those, and it is openly suggested in the bidding documents to all bidders. Those are more reasonable situations. But if there is a local public sector employee who's asking the customer to go for a certain vendor, that is something to be watched out for. In either case, my recommendation is to properly vet the vendor. I don't think anybody can stop a company from doing their required due diligence, comparing their experience, backgrounds, and competitiveness with other vendors. And if something doesn't look right, I think we need to flag it, even if it is at the direction of the customer. Then, of course, there are other red flags like unusual payment arrangements, something, paying to one party, contracting with another party, making an exception in the way payment is made, and generally avoid cash payments at all costs. In this day and age, I think any cash payment is definitely a red flag here. And then, how are we looking at invoices? And I'll talk more about that in documentation. But what is really required is when we are paying to these third parties, we have to do a detailed review of what we are paying them for. What is the difference between their own fees versus a reimbursement of sorts, and what kind of documentation and backup we are gathering before we are approving such payments. uh, Deep discounts, discounts which are beyond normal, commissions that are higher than market rates. These are good red flags, especially from an audit perspective, to cover, and really asking why, certain third parties were compensated higher. Are we giving them enough buffer to pass on some of it back to the end customer as a kickback? And then the reluctance, to cooperate. So we see that very often when we deal with especially small and medium enterprises, who do not really understand the compliance requirements applicable to a multinational company, and they may see that as cumbersome, tedious, and we really have to understand where they are coming from. Is it really from a cost standpoint, or is it because they know that they won't be able to comply with these requirements because it would prohibit or inhibit them from doing the business? So such reluctance can only be observed when we are directly interacting with these third parties and not just limiting to a background or a paper due diligence. So I think there may be a lot more red flags. These are really built on our own experience, but knowing and educating people on these red flags is just so much more important than having policies and procedures, because when we will get to know these issues, it's really when somebody has identified something and raised their hand. So moving on to the last section here, and Masha, you can flip the slide, is what do we do? What is the compliance program that looks at the risk for third parties? And we always think about our compliance program and three buckets, prevent, detect, and respond. So it starts with, like I said, need assessment. And of course, due diligence. Now, due diligence people think of due diligence sometimes as having a third party looking at their profile, their officers, and just doing media search and adverse news search. The fact of the matter is that due diligence has so many limitations, especially in a country like India, where the local databases, the central databases have so many limitations. There are no central records of convictions, of prosecutions. And so and sometimes these companies don't even have a public profile or even a website. So what kind of due diligence we do and rely on is going to be absolutely critical. What I really recommend is, for the higher the risk of these parties and the less the information available, the more should be interpersonal touch points. We actually interview each and every third party that we hire, and that is categorized as a high risk. And in some cases, we plan to make a site visit to these third parties to see whether they actually exist or not. So again, the due diligence requirements may vary by the level of risk these third parties come with, but don't rule out anything additional to what's a standard. Onboarding becomes critical. We make sure we train some of our high risk third parties to set expectations, to be very clear. We can put in all the language in our contracts, but we all know how many people really read the contract. So it becomes very important to make it very clear to these third parties on what the company expects and how do we operate. And sometimes, in these discussions, we ask strict questions and we say, hey, how are you going to get this done? It's how things are in India. And if a third party falls into the trap of that trick question, that tells us that we have to be very, very cautious with such companies. And then trainings, trainings not only for our own employees, but trainings for these third parties. One thing I would like to add in the prevent section is how robust is our contract. And then many times, what all that's left is to fall back on a certain contract provision, if not for anything else, but to initiate a termination when we see something wrong. And then, sometimes you go back to the contract and you really realize that we hadn't put enough mitigants based on what we had identified in the due diligence to take a stronger action on a third party. So identifying those red flags and using our contract to put in the right clauses up front is going to be a good way to safeguard the company at a later stage if something goes wrong. And then detect is important too, because once we've onboarded the third parties, we can't simply forget about them, which sometimes happens. But how do we continue to keep the monitoring and auditing mechanisms on these third parties is important. I talk about payment controls earlier. We take this very seriously, where any payment that is made to a third party cannot simply just go through like a three-way match between a PO and an invoice and a GRN. We actually do a more comprehensive invoice review where we tell our third parties that we want detailed line items breakup of everything that you're charging us for. And we match that against their contractually agreed service fee, agreed reimbursements. All the reimbursements have to come with the backup of a legitimate invoice. For example, in a customs invoice, we would ask a legitimate backup for custom duties paid, documentation charges, warehouse expenses. And many times we see these other and miscellaneous, and those are invariably questioned by our finance teams before any payment is released. So I personally think that is a very strong mechanism to keep these third parties in check and prevent any unauthorized or any additional payments going to them as a buffer. And then, of course, audits and reviews. Having audit rights and contracts always helps. We want to be sure what kind of distance we want to create between the company and a third party, but at the same time, we know that if something goes wrong, ultimately these third parties will be deemed as companies' representatives. And therefore, having audit rights helps, where if there's a situation, we have a red flag or we identify something wrong, we can hold these third parties accountable. And then finally, respond. I think the whistleblower program a company runs is extremely important to raise issues. Most of the issues we find are through these whistleblower programs when somebody finds something wrong and they raise their hand, and we open our program to our third parties as well, because it may so happen that really the third party is being pressurized by our own employee to do something wrong, and we want to give the channel and an option to those third parties to be able to raise concerns, and not feel pressurized to act to do something unethical. So extending your whistleblower program to the third parties always helps us. And then finally, how do we resolve and respond to the red flags? uh, I think it's very important to document the red flags, to document how we are mitigating them. Are we putting the right clauses in the contract? Are we putting in the right ongoing monitoring mechanisms to deal with certain risks identified in the beginnings stage? So that really helps the company create a defense and also to hold people accountable internally when any red flags are identified. So we could go on and on how each of these areas need to be detailed in implementation, but I wanted to give a sense of how to think about an effective compliance program to mitigate third-party risks here. And with that, I will hand it back to Richard to take over from here.
Yeah, Ritu, thank you very much. That was excellent and extremely practical. I think, as you can all see, we've packed a lot into this program. We're running short here on time. So if you have any questions or additional comments, please pass them on to us and we'll get back to you. But I want to thank all of you who have participated, and special thanks to our panelists, to Ritu and Alina and Jerome, for really an excellent presentation on a difficult and challenging topic. So thank you all very much, and we will be back in touch. Take care. Bye. And I'll turn it back over at this point to RT to wrap up the program.
Thank you, Rich. And once again, everyone, that was Ritu Jain, Chief Compliance Officer for Asia at General Electric in Gurgaon, Alina Arora, Partner at L&L Partners in New Delhi, Richard Dean, Partner at Baker McKenzie in Washington, D.C., and Jerome Thomas, Partner at Baker McKenzie in Chicago. As a reminder, this webcast has been recorded and all registered participants will receive links to the recording and presentation materials once this webcast ends. This webcast was brought to you by Baker McKenzie, the Business Ethics Leadership Alliance South Asia Chapter, and Ethisphere. This concludes our webcast. Thank you all for joining us, and goodbye.